Hi, everybody. I'm Jeff Tockman, the Referral Navigator, and we're here today with the Executive Virtual Roundtable. We have, as usual, our host and organizer, Jess Coburn, and we have our special guest today, Alan Crane. Alan Crane happens to be a good friend of mine and a client for a long time. Hello, Alan. How are you?
All right. How are you? Thank you very much to both of you for allowing me to be here today.
Fantastic. Jess, we'll get started with you. We'll talk a little bit about the Executive Virtual Roundtable, the tool that we're using, StreamYard, how it's broadcast live. Jess, tell us a little bit about the environment that we're in right now.
So we're all at home, right? Because we're all in lockdown still, and we're all distributed. We're broadcasting the video live right now. For some reason, it's not going over YouTube, so that's why I keep looking over my shoulder here. But we are live on Facebook on a couple different channels there, and people are able to see it. And then we'll be able to record it and post a recording later on YouTube. So anyone that missed it, they'll be able to watch it on demand. We're using an application called StreamYard, and StreamYard allows us to broadcast on multiple platforms at the same time. Now, because we're all working from home and we're all on different Wi-Fi networks or broadband networks, we're going to have some technical difficulties. I know one of the videos, Jeff, you froze and took a break, and we'll carry on with it. And we might have some audio issues, but don't worry, it's all going to work out. So there you go. There's the platform. Now, the Executive Virtual Roundtable is a continuation of a series that we came up with, Jeff, you and I, to interview experts in their various fields, such as Alan here, to talk to us and share with us information that would be useful to business owners, CEOs, and business leaders. From within Facebook, users can go on the Facebook pages that we've shared this, and we've shared that link in all the different areas, and they can leave a comment. When they leave a comment, it'll pop up for us, kind of like this, and we'll be able to respond to it. So they can actually keep the conversation interactive and live with us. The one thing that we'll ask for from time to time is for Facebook users to go ahead and click the like button or the share button so that we know that there's the connection there and that everything's going well. So with that, I'll turn it back over to you, sir.
Thank you so much, Jess. Jess, your business, Applied Innovations, has a lot of experience in helping customers to run their business effectively and focus on their core value proposition, which is typically not IT like you provide. Tell us a little bit about your company, the background, maybe when it got started, when you started the company, what was the vision then, and how has that vision changed over time?
Sure, Jeff. So I started the company back in '99. Initially, we started as a managed cloud provider providing cloud hosting. Over the years, technology's changed and the platforms changed, and with that, our service offerings have changed. Today, our company's focused on managed cloud, IT, and cybersecurity. Cloud still plays a big role in what we do on a day-to-day basis, just as it plays a big role in everybody's business today. We double down on cloud, but we also augment it. So we're able to help businesses wherever they are, whether they're just in the cloud or they need help with their desktops, their phone systems, and their cybersecurity especially. The goal of the Executive Virtual Roundtables is really to help businesses through these times and help them understand what's out there and what their options are. So we're interviewing experts, as I mentioned earlier, and we're sharing that information. And I'll ask that if anyone wants to a specific topic or they want to be a part of one of these, by all means, just leave us a comment or shoot us an email.
Fantastic. We've had several of these Executive Virtual Roundtables already, and our plan going forward is to do them at 3 p.m. Eastern Standard Time every 2 weeks. Tell us about your vision for the Executive Virtual Roundtable, the types of guests that you would like to have on, the type of audience that you would like to have to participate in the comments and interact with us, your vision for what you hope to do to help people through the content that we're providing. Tell us about the vision.
Yeah, so the vision is really, as I mentioned earlier, to share information that's helpful to business owners, CEOs, and business leaders. It's to bring on experts and give awareness to what's going on there. Part of that's also to spotlight different business owners and CEOs to talk about what they're doing. You know, businesses across the globe are changing and changing drastically. It doesn't matter what industry you're in or what your business does. Your business has been affected by what's going on. And we want to help share that knowledge. You know, a great example of it would be Michelle Ising from Designing Events. I interviewed her on the podcast Cyberside Chat. Her business was a corporate events company, and they were focused on putting on corporate events, conferences, and shows. where people would travel to, the big conference center, and they would do it. Well, her business changed overnight, and she pivoted to doing virtual events and virtual conferences extremely fast and very nimble. You just really have to hand it to Michelle how quick she was thinking. Now, I was talking to a friend of mine that's also an IT company out of state, and he was mentioning that one of his customers was out of business, that her business was completely over. I said, well, what do? They do corporate events, similar to Michelle. They do conferences and events like that. I shared with them the video that we did there, and it helped the lady overnight. So she quickly, saw that, hey, there's still an opportunity for my business. I can do just like Michelle's doing. And she jumped at it, and she's doing great.
I'll tell you another benefit, which I think you're aware of from the prior executive virtual roundtable that we did. We had a guest on, Evelisa Thomas, who is an HR consultant. And she shared with me that after we had the EVR with her as a guest, she had been in a situation where she was working with a really big new prospective client that she wanted to land. And that prospective client asked her to share some information with them about maybe a podcast that they had done or a video that they had recorded. And she simply clicked the link to the EVR, pressed forward, sent it on to them, and landed the client. So it was a great opportunity. I don't know if you knew that from Evalisa's yet.
No, I was aware of that. That's fantastic. I'm excited to hear that. So I've seen, Jeff, prospects come to us that have learned of it from the videos. The video we did with Evelisa, I think we had about 1,400 views on that.
Wow, fantastic. I think we can certainly work on, we're just getting started here with our audience and building our audience, organically. And there are, of course, a lot of other ways that we're going to build this audience over time. So it's great that we have good numbers of people who are viewing the video now. And I think there's just certainly more to come. And especially from the quality of the guests that we've had so far and the quality of the guests that we have today and going forward, I think we're going to provide a lot of great content for people. People are going to be interested, and we're going to have, I think, even more interaction. So I hope that people will leave a question in the comments or a comment in the comments that we'll be able to see on Facebook. And if you can, go ahead right away now. Click like, click share, spread the wealth, spread the knowledge, and please leave a comment. We'll try to address that question for you. Jess, anything else before I get started with Alan? Something else you want to mention about your hopes for the EVR today, your thoughts about the topic of bankruptcy, anything you want to mention before I get started with Alan?
I think we should get to it. And, we've got a number of people who are watching it now. I'm sure they want to hear from Alan.
Fantastic. Alan, thank you so much for joining us. Wanted to get your thoughts, just a little bit of background perhaps on you. Where did you grow up? What did you learn when you were young? What did you learn in school? What did you learn through your years of experience in being an attorney? Focused on bankruptcy. Tell us about your strengths and your background.
I grew up in New Jersey. I moved to Florida during college. Went to law school over at Nova. What did I learn? I learned about working hard, telling people the way it is, and being very straightforward, and preparation and knowledge.
That's excellent. You and I have been hosting an event for several years, our 4th year anniversary here in May, called the Trusted Professional Advisors Lunch, which has gone virtual. So you also are an event host. Tell us about the kind of people that come to that Trusted Professional Advisors Lunch that you host, and what was your thought putting that together?
The key to the members of that group are that they all, in some way, help businesses or business owners and advise them. And so I was never able to find a group that actually did that from different practice areas. So not only do we have lawyers and different types of lawyers, but we also have accountants and bankers and other related professions. And so it is a roundtable conversation. So if somebody has a problem with one of their clients, they're able to bring it to the table and get different points of view so that they can better serve their clients. And that's the goal. It's about service to clients and coming up with a way of participating and getting ideas and serving their clients better, because the knowledge is the key.
I think it's wonderfully altruistic and also very business and selfish at the same time, which is perfect, right? It really serves a lot of the people who are there, yet at the same time, it's a group that you've organized. So you have the professionals that really make natural referral sources into your bankruptcy practice at the table virtually now, but physically at a lunch table before the COVID issue. And it's been a great opportunity. What I commonly get in terms of feedback from that group, being the moderator, is that people are able to learn a lot more about someone and whether they want to invest more time into having a one-on-one meeting or going to lunch one-on-one with someone after that group event, because we're having a discussion about a real issue. In other words, if you've been to like a chamber event or a BNI event where people are simply pitching themselves around the table, you learn how good they are at pitching themselves. But in our in the Trusted Professional Advisors launch meeting, we go around and do a brief introduction, but it's really focused on a conversation about a very tough issue. I know that that really fit your personality. Before you and I even met, you were telling me that one of the best ways to do business development was to have conversations with other attorneys. And when they had questions about bankruptcy related issues, you really enjoyed actually sharing information for them that could be useful. If one of their clients had a small bankruptcy issue or a matter that was related to bankruptcy, sometimes you really enjoyed having those conversations. And now you can do that through an organization and a group that's coming on its 4th year anniversary. Tell us your thoughts about the future for the Trusted Professional Advisors Group.
And you bring up a good point. One of the things that we do and forces people to learn about the knowledge that and experience that one of our professionals has, because they're not just saying, I'm Alan Crane, I'm a bankruptcy attorney. We're actually talking about substantive issues. And so people get to know the depth of experience that each of us have in our various areas. And so we're going to continue that. And right now, we've expanded virtually, as you said. That has allowed us to bring in people from all the way from Miami to to the Martin County area. And I expect that we'll continue doing a lot of it virtually because that allows greater participation and more economic for our participants. Again, it's all about having people come and being able to help with their problems and the problems that they're dealing with their clients and finding creative solutions. It's all about the solutions for the clients.
Excellent. Yeah, I think there's a great opportunity to expand on necessity being the mother of invention. We needed to go virtual, but of course, now we've invented something that may continue in perpetuity, doing something virtually for that group. Tell us a little bit about your firm. FurrCohen is a boutique bankruptcy firm in Boca Raton, Florida, and you have within your firm a couple of trustees. Maybe you can explain to people what that means and why your firm is so well known and has such a good reputation in bankruptcy.
The firm has been around for over 40 years. I've been practicing for 27. I've been practicing bankruptcy for over 20, and I've been at FurrCohen for over 17. It has a great reputation as being a bankruptcy firm because there are 6 lawyers. We all practice bankruptcy. Some lawyers do a little bit of other things, but everybody practices bankruptcy. And we do it from different, we do all of the various areas of bankruptcy. So all of chapters of bankruptcy and from all of the different sides. We'll do not only just the filings, but we'll also do the litigation, the appellate work. And that breadth of experience and that well-rounded experience lets us help our clients even greater than we would if we were just did one or the other. So we have 2 Chapter 7 trustees in the office that are appointed on their panel trustees in Chapter 7 cases. And what their job is to liquidate the cases and the assets in those cases and distribute them to creditors. And so oftentimes I'm hired to represent them and to look at the various issues, whether it's a bad debtor and the debtor did bad things, or it's recovery of assets that the debtor had and wasn't able to recover before the filing of the bankruptcy, and we'll bring that litigation, and I'll represent the trustee in that, and I'll actually do the litigation for the trustee in those cases.
Tell us a little bit about the current environment and your business in terms of the types of clients that are best for you and your firm to work with. You can work with a lot of different types, and maybe talk about your ideal clients at this point, the ones that are going to, of course, generate good revenue for your company, and also be clients that you can serve really well, that you can provide a lot of value to in the bankruptcy area. And then also, if you could, don't just touch on the clients, tell us a little bit about the types of referral sources that you like to build relationships with. Certainly other attorneys that maybe practice bankruptcy, maybe have a conflict, could refer it to you, but certainly attorneys that don't practice in bankruptcy. Tell us a little bit about your ideal clients and your ideal referral sources.
Well, I'll start with my ideal referral sources, and those are commercial and business litigators, business transactional lawyers, employment law lawyers, accountants, and those are the strongest referral sources that I end up with because they're on the front line. They'll usually see a client having problems before it gets to the bankruptcy attorney. The bankruptcy attorney should be, and usually is, the attorney of last resort. So they'll have gone to their general counsel, outside general counsel, or there'll be a lawsuit that's involved, and they'll use those and go to those people first, and then they'll refer to the bankruptcy attorney. I represent anything from medium size to small businesses, to individuals. I will work on the creditor side or the debtor side. So I've represented landlords in this environment, commercial landlords especially. I represent businesses that are having problems due to the COVID-19. But I've been doing this for a long time now. And so those are the types of clients. And I'll take the individuals as well. But it's the businesses and that I expect to see a lot more of, the businesses and business owners.
Thank you. Let me put up a new banner here, and we'll talk about this first one. It says on the banner, as everyone can read, bankruptcy is perceived as taboo by many, but many businesses have leveraged it for restructuring successfully. So which is it?
A little bit of both. Bankruptcy being a taboo, certainly at one point in time it was, probably less so after the 2008 crash. And so more so, it is a taboo psychologically. It is not a taboo economically, and it is not functionally a taboo. Bankruptcy gets everybody in one room, and gets creditors. A company has multitude of creditors, and it gets them in one place and gets the debtor to deal with those creditors at one time in one forum, the bankruptcy court. And usually I can get done in a bankruptcy much more economically and efficiently dealing with those creditors than they could if they were to try to deal with them one at a time outside of the bankruptcy context. And so therefore it becomes an economical way of dealing with it. For the individuals, a lot of my clients will, within a year or two of getting their discharge, have normal credit scores, 700 plus, and can get debt, incur debt, buy cars, buy houses, and I've not seen it as a problem for any number of years. So it's more a perception issue that people have, but from an economic standpoint, oftentimes it is the most effective way that a corporation can reorganize and get themselves and save themselves.
That phrase reorganization is used commonly. Tell us, what's a working definition of reorganization? What does that mean to people in business?
It is a way that they can it's for a business or an individual, and there are two bankruptcies that would sort of do that, Chapter 11 and Chapter 13. It is a way for people to get and a business to get a fresh start, to take the debt that was there, the unsecured debt, and come up with a payment plan, usually paying pennies on the dollar. The secured debt that's behind, that will get stretched out over a period of time generally, and you can work with the creditors to try to do that. So that's what you're talking about, reorganizing. In some of the large cases, larger companies where you see they have multiples of stores. So if you have Neiman Marcus, who's just filed a bankruptcy, they have multiple locations all over the place. One of the things that will happen is that they will start shutting down stores, and they'll have leases. Inside of a bankruptcy, the landlord's claim for future damages in a landlord-tenant situation is capped. So they can limit their exposure to liability while working with their other creditors to minimize the debt, effectively use their income, and move forward in a restructured sort of way to become profitable again.
Let me go to the next banner and we'll take a look there. Right now, businesses are focused on the CARES Act, PPP, and EIDL. How does bankruptcy fit into that conversation? Maybe you could just give a little explanation for those who don't know those three things, what they are briefly, and then how bankruptcy fits in.
Okay, so the CARES Act is something that Congress and the president signed into law, and it had several facets to it. And it's a response to the pandemic. One of them is PPP, which is the Payroll Protection Program, and you've heard a lot about that in the news. And the EIDL is also for small business loans. I'm going to spend more time on the CARES Act and the PPP program because I think a lot of your audience needs to know about those things. The CARES Act, one of the things that the CARES Act did in a bankruptcy is raise the limit for a year for subchapter 5, chapter 11s. Subchapter 5, chapter 11s is a new form of bankruptcy that just went into effect in February that is designed for small businesses. And it raised the limit to $7.5 million for the year following the entry of the passage of the CARES Act. And that sub 5 chapter 11 is a great tool for small businesses to reorganize their debts and move forward in a more economical way and a faster way than they would in a traditional chapter 11. The Payroll Protection Program was replacement income for allowing employers to make their payroll. And so basically it was about a year's worth of payroll that a bank would look at, come up with an average. For people making more than 100, they would only count the first 100. They would multiply it by take an average monthly and multiply it by 2.5. And the employer from February of 2020 through had to have the money spent by the end of June. Has to use 75% of that money towards payroll expenses. They can use the rest for mortgage or rent, and as a result, if they do that and they follow that and they have as many employees or more than they at the end of June as they did in the middle of February, that debt will be forgiven under the CARES Act. The CARES Act also provided additional funding under the small business loans and allowing for larger businesses to partake in the government funding as well. And they're either low interest loans or, in the case of PPP, forgivable loans, which means that if the company does the right thing, traces the money correctly, spends the money correctly, uses it for the payroll the right way, then that debt will be forgiven. So basically it becomes a grant, free money for that business. I lost your audio, Jeff.
Sorry about that. The question I had was about bankruptcy and how that plays into the CARES Act and the companies that you're seeing who are participating in that. What are the points that you want to raise for folks who are thinking about utilizing CARES Act or that already have? What's your perspective?
The Small Business Administration came out with some rules that said that if you're in a bankruptcy, you're not eligible to take advantage of the payroll protection program. However, that advice by the Small Business Administration has been struck down by a number of bankruptcy courts. And so it does look like a company that is in bankruptcy, if they can find a bank that will lend to them, will still be eligible to do so, irrespective of the guidance of the Small Business Administration. But we're going to come to the end of the payroll protection program anyway. And so most of companies who have applied and are going to get the payroll protection program money probably have already gotten it. And so it will be, again, a loan that would be hopefully forgiven. If not forgiven, it is a dischargeable debt in the payroll, in a bankruptcy. And so that's where I see things going. Hopefully most companies will use the payroll protection program as it's intended, and then it's not even a debt.
Yeah, Alan, I think that's an important point because a lot of businesses are focused on the PPP and the EIDL today, and they see it as a godsend. And for a lot of businesses, it is, right? It's a little more runway to keep the business afloat. But what they're losing track of is that there's still a lot of risk when that money runs out. That money's good for 8 weeks. It's going to run out, and then what? And they need to really focus on that. Real quick, Jeff, just want to say hi back to Dave. So appreciate the comment, Dave. If you got a question, please do add it.
Thank you so much. Alan, let me go to the next, the banner here, and we can read it on the screen together. Let's say for someone who says, my business is in distress, should I tap into my savings, 401k, IRA, and retirement vehicles to save my business? Obviously, any advice you're giving is going to need to be vetted out for an individual. But in general, what are your thoughts about this kind of question?
I think what I would say, before a business owner starts tapping into a 401k, IRA, or retirement vehicle, they should contact a bankruptcy attorney. If you're at that point, and then you're at the point that you really need to be seeing a trusted advisor, a bankruptcy attorney or accountant, because there may be other ways of reorganizing the business without you taking your protected savings. I ran into this too many times during the 2008 crash and the Great Recession of 2018. I saw people sink their life savings into businesses that were just throwing good money after bad, and where in a bankruptcy that money would have been perfectly protected was now gone, and they had to rebuild their lives all over again. So before going into those monies, you should seek the advice of not only your accountant, but a bankruptcy attorney, because you want to find out what your options are before you just start sending good money after bad, protected money, and losing it, and losing your life savings.
Yeah, Alan, I think that's good feedback because a lot of business owners treat their business as their child, right? You've grown it from a baby and now it's this big thing, and you don't want to see it get hurt or die. And so you'll do anything for your baby, right? And or in this case, your business. And by bringing in a trusted advisor like that, or a team of trusted advisors, you're getting someone that's disconnected from it, that's giving you a 40,000 foot view, that's really looking at it without that same prejudice and concern.
That's exactly right. And that's what a business owner at that point in time needs. They really need to know whether or not, if they put another $50,000 to $100,000 in, is it really going to save the business, or is it really just eating up their retirement savings, and the business maybe a month or two later will be in the same or worse position. And so you are exactly right that people are emotionally involved in their businesses, and understandably so. They have spent years building a business, and sometimes it's been generations that have gone into building a business. But you have to have somebody out there that is disconnected, who can show you the ways around uh, using up your valuable retirement savings to save the company if it's possible to save, and then taking a realistic look at the company and whether or not that business can be saved at all. Again, with the sub 5 chapter 11s, Congress gave bankruptcy attorneys more weapons in their arsenal to help small businesses to reorganize more efficiently.
Let's go to the next banner here that we see on the screen. What about a mortgage on my homesteaded property? Maybe you could explain what homesteaded is to people briefly, and maybe give us an example of where that would come into play.
Florida has one of the most generous homestead laws in the state, in the country, which means that if you have equity in your property, it's exempt from your creditors. And so the one baby that people care more about than the business and their own children, obviously, but the proverbial caring about is the business and their home. And they want to use it, and they want to keep it, and they should. And before taking a second mortgage on your home that has equity in it, that is perfectly protected from all of your creditors, before taking that money and spending it into the business, again, it is the time to talk to your accountant, your a bankruptcy attorney, and other trusted professional advisors to make sure that this is a good investment of your money that has a good chance of return, or are you throwing good money after bad and losing your one of your most valuable assets, your home.
Maybe you could help us to understand, sort of on that razor's edge, a person, let's say John comes in, you're able to save his home. Jane comes in, you're not able to save her home. What are some of the key differences that might make that distinction as to whether someone's able to keep their home?
If they need to be able to make the monthly mortgage payments on the home, and as long as they can continue to make the monthly mortgage payments on the home, they should be able to keep it. But if they have borrowed money, if they're making money from a business and that business starts to tumble, and then they take a second mortgage out, and now all of a sudden their sole source of income, that business, is no longer going to be able to function and provide enough income to pay salary to the owner to cover the first and now the new second mortgage, they're unfortunately going to be in danger of losing that property. Not only might they lose the business, but they might lose their home. Someone who has not invested money into their business and taking the valuable equity out of their home may be able to keep it because they've kept their mortgage payment lower and they haven't taken the equity out to invest it into a business. And so even if their income does suffer some, their mortgage payment hasn't gone skyrocketing up.
Let's go to our next banner about merchant cash advance. What is it? Why is it bad? How could it be good? What are your thoughts about merchant cash advance?
I think in my experience, when I see a client with a merchant cash advance, I know that the company's already in trouble, and maybe it may be even too late to save it. What a merchant cash advance does is they're really disguised predatory. What they do is they are selling their receivables at an interest rate that is more than what usury would be. So it would be more than 25%. And so they are selling now their future receivables. and they're paying them usually on a daily or weekly basis. And so a large amount of money is going to then come out of the business's account to pay the daily merchant cash advance company back, or on a weekly basis. And it is a great cash drain. Again, it's another sign that the company is in trouble and may have better options. And so speaking to a trusted professional advisor on ways around that, and either through more traditional commercial financing, or bankruptcy, or some other maneuvering that can be done, and prioritizing debt and prioritizing expenditures may actually save them and avoid the necessity or perceived necessity of taking out one of those predatory loans.
Let's go into a few of the chapters in bankruptcy, 7, 13, and then 11. So first, chapter 7 bankruptcy. What is it? Why do people use it? Maybe, again, on that razor's edge, John comes in, we can do a chapter 7 for him. Jane comes in, kind of, but we're not able to do it. What's the difference?
Well, let's talk about what it is first. A chapter 7 is a liquidation. There's going to be a chapter 7 trustee appointed to look at the assets of the company or the individual, because a chapter 7 can be for a business or it can be for an individual. And what will happen is that for an individual, the non-exempt assets that person has will be given over to the trustee, whether the debtor buys it back, someone buys it back for them. But the goal for the Chapter 7 trustee is to take those non-exempt assets and any other asset that the debtor has that is not otherwise exempt from creditors and liquidate it and distribute it to creditors. For a corporation, it is the same basic principle. The corporation is out of business. The debts are going to be, or the assets are going to be liquidated. There are no exempt assets for a business. And so all of the assets of the business will be liquidated and distributed to creditors. And so that's what it is. Oftentimes it will depend upon whether or not an individual qualifies, because there are certain income to debt ratio qualifications that may make someone not eligible for a Chapter 7 bankruptcy. Also, some people don't have the ability to pay, don't want to lose their non-exempt assets, and certainly don't want to pay or have the ability to pay the trustee in lump sum for those exempt assets. And so therefore they'll file either a Chapter 13 bankruptcy, which is only for an individual, or Chapter 11, including a sub 5 Chapter 11, which can be for a business or an individual.
All right, let's go on to the next one. We can always go backwards if you like to the Chapter 13. What is it? Why would people use that?
Chapter 13 is a payment plan for an individual. A corporation cannot make use of it. There are certain debt limitations, about $420,000 on unsecured debt and a little over $1 million for secured debt. And it puts somebody on a payment plan for 3 to 5 years, depending upon if their household income is above or below the median income. And it will allow people to pay their unsecured creditors, usually pennies on the dollar. Their taxes, if they're behind on taxes, it'll allow them to pay that out over 5 years, and the IRS will accept, because it doesn't have a choice, a payment plan of 5 years. If someone's behind on their mortgage payment, they can either surrender the property, say, I don't want to keep it anymore. They can, if they're current, they can just reaffirm or continue making the payments on it and continue and keep the property. Or they can cure and maintain the property, which means that they can pay the arrears over 5 years while making their normal monthly mortgage payment. And the last thing that they can do is try to work out a loan modification with the lender. And so those are some of the things that you can do in a Chapter 13 bankruptcy. One of the things that we saw, because I think that this is going to come up again, people in 2008 had multiple mortgages on their properties. And what happened is that the value of the property went below the payoff of the first mortgage. And through a Chapter 13 and through a Chapter 11, we were able to strip off the second mortgage, and it became an unsecured loan. And so we were able to save their property, get rid of that second mortgage under those circumstances, and allow the debtor to get a fresh start. In bankruptcy, it's all about allowing the debtor to get an honest debtor to get a fresh start, to move their lives and their financial lives forward.
You had mentioned before to me before this broadcast that one of the skill sets that you have is the fact that from your experience, you've worked on both sides, the creditor and the debtor, the one lending the money, the one borrowing the money. What are some of the tactics that you use based on that experience?
So I know and I understand what the creditor is going to be looking for. I do understand where the pressure points are. I do understand what, from the debtor's point of view, what I can basically force the creditor to accept. It's really a function of disposable monthly income and liquidation. And so understanding the dynamics of all of the different sides in a Chapter 13, the debtor side and the creditor side, helps me provide better advice to my clients.
Let's go now to the last of the three, the Chapter 11 bankruptcy. What is that one? Who does it apply to? And why would someone decide to use it or not use it? What's sort of on the edge there?
So traditionally, it's for a corporation or an individual who wouldn't qualify for a Chapter 13. And it is the most complex area of bankruptcy. You'll see large corporations, as I was using Neiman Marcus as an example, because that was recently filed, or small companies that need to and mid-sized companies that need to reorganize. Again, for individuals, less so, but if their debts are too much for a Chapter 13, then they will file it. In a traditional Chapter 11, you have it can be very expensive, but it is also a place where you can bring all of your creditors into one forum and try to negotiate a deal with them. And in a traditional Chapter 11, it's really about the deal making that you can do through that process, and to get a confirmed plan, and because you need to have the creditors vote for the plan. And so that brings us to the sub 5 Chapter 11, which, as I said, came around and went into effect in February. And it allows small companies, even if there are no accepting classes of creditors, can still confirm a plan. So even over the objection of creditors, can confirm a plan. And it is a lot of the weapons that a creditor has in a Chapter 11 case were taken away in a sub 5 Chapter 11 case, because things like the absolute priority rule, which requires an owner to purchase their equity in a company back, doesn't apply in a sub 5 Chapter 11, but does in a traditional 11. Also, the voting, if you could not get enough creditors to vote for the plan in a regular Chapter 11, the case would either be converted or dismissed. Where in a sub 5, you can, as I said, you can confirm even if all the creditors object to it or don't vote for it. In a sub 5, automatically the corporation and business is entitled to a discharge, where it's something that you would have to look for in a reorganized Chapter 11 in a traditional way.
Some attorneys describe themselves as asset protection type of attorneys. To what extent does your firm help clients with asset protection? How would you define asset protection? What does that mean to a business owner?
By the time somebody usually goes to an asset protection lawyer, it's too late, because most of those types of things, most of the avenues can be set aside as fraudulent, because usually when you're going to see an asset protection attorney or professional, there are already financial problems that somebody's trying to deal with. And I'm going to separate that from an estate planning attorney, where somebody might, at the beginning of their career and before the business is even started, start looking at how to protect themselves in the event of death, in the event of a business failure, and will learn how to make sure that those requirements are followed to give the greatest protection. And that is definitely worthwhile. And you do that before there's a problem with the business, because by the time that there is a problem, then it becomes pretty much too late. A trustee or creditors may be able to come in, and generally it's going to be a trustee, come in and avoid those transfers and that planning.
Hey, Alan, so I'm curious. So we hear on the news that we're going to see, 20% of Main Street go out of business. So these businesses that are looking at that have tapped their EIDLs or their PPPs, and they're looking at what the next step is, now would be the time for them to engage with their accountant and their attorney, right?
Yes, absolutely. I gave this advice earlier today to another lawyer. The earlier in the process, I can get involved, or other bankruptcy attorneys can get involved, to sort of figure out what is going on and what the plan is. And the more time I have to work with them, the better generally the result is going to be than if I have to file at a moment's notice. So not that I won't file it at a moment's notice, but the results are much better. The planning and what you can do and what you can't do, and the time that I have to work with them certainly lends itself to better results. And I've seen that time and time again.
And with all these businesses that we hear are going to go out of business, how many of them do you think are going to be able to take advantage of bankruptcy and legitimately restructure and reorganize and come back?
I think that is going to depend on future income. And so for those businesses that are behind in their debt, but there's income that's going to come in and is going to come in, either is starting to come in or is likely to come in very quickly, those businesses should be able to save. For companies that there is no real sight of income coming in, they're going to be closed, they're going to stay closed, then now you're looking at liquidation, or you're really looking at the owners and protecting the owners and seeing what the best way for them is, because the business probably at that point in time isn't going to be saved in its current form, because in a reorganization, income is one of the key factors about being able to reorganize.
Got another banner up on the screen: automatic stay, postponement of payment of contractual obligations. Perhaps you can explain that and how it would apply to some business owner out there today.
So the automatic stay goes into effect as soon as the petition is filed, the bankruptcy petition is filed. And what that does is it prevents all collection activities from continuing. So creditors who have judgments cannot try to garnish bank accounts. They cannot continue with lawsuits. Again, it's all designed so that everything comes under the umbrella of the bankruptcy court. It does not, so for foreclosures and evictions, it stops everything in its tracks. And so that's what the automatic stay does. The postponement of payment, generally in a Chapter 11, it's going to be a little while before you have to pay your past due, anything towards your past due obligations. And some of your current obligations, you may be even able to get some breathing room, like with your landlord or on other secured debt. And you may not have to start paying that as quickly. And so that is designed to give the debtor some breathing room to get some of that income started and back going. Again, it's going to all be about the income.
Real quick, this probably falls in line with that. I know a number of business owners, Alan, and a lot of business owners are holding onto their cash right now, looking for that opportunity, looking for that struggling competitor that maybe is on the verge of going out of business as a potential opportunity. At the same time, though, they have to worry about things like clawback and all that, right? So if I were a business owner that was looking at a struggling business that was potentially going into bankruptcy or is in bankruptcy to acquire them, what would I have to look out for?
So if you are looking to acquire assets from a bankruptcy trustee or a debtor in possession through a Chapter 11, you want to have an experienced Chapter 11 lawyer, bankruptcy lawyer, looking at it and representing you, because there's certain language that you want in the sale orders. But the sale order, because everything is noticed out to all interested parties and creditors, and they have an opportunity to object and to be heard, the bankruptcy court sale order will provide generally protections so that nobody can come after the purchaser of that property. So it's an order generally free and clear of all liens and encumbrances, and those liens now attach to the proceeds of the sale and not the actual property that's being sold. So it removes the liens, and so you can be a purchaser in good faith and determined by the bankruptcy court to be a purchaser in good faith, and that gives you a lot of protection that you would not have outside of a bankruptcy sale. And so what you're talking about in clawbacks is if somebody were to buy from the business the substantial amount of the assets and not pay reasonable equivalent value for it, or the debtor was selling it with the actual intent to hinder, delay, or defraud creditors, and a trustee could sue to get the value of the assets or the value of the assets back. Again, doing it through doing that same sale through the bankruptcy court and through the bankruptcy process protects you from those potential eventualities.
So you really have to watch out, and you have to go through the right process. You can't try to do a backdoor deal, basically, because you could be out both the asset and your money.
Yes.
Let's
I
move
always
in.
say that the best lawsuit is the one that's never filed. So if you can do something the proper way and there is never a lawsuit, then that is much more economical for a business than having to go through a lawsuit and even winning. So the best lawsuit, again, is the one that is never filed. So you make sure, a good bankruptcy attorney is going to make sure that the ability for other people, whether it's the trustee or creditors, to make mischief in the case is minimized, or at least identified, and everybody knows what they're getting themselves into.
I'm going to go towards wrap-up mode. We're going to be finishing just briefly here. First to you, Jess, and then I'll go back to Alan. Your thoughts on our executive virtual roundtable today, your reflection on the content today, and any final comments or questions, Jess.
Alan, thank you for participating in this and sharing your knowledge with us. It's been extremely valuable and informative. There's a ton of misconceptions around bankruptcy that a lot of small businesses don't understand. They don't realize that it is an option for them. And it's not just that, final nail in the coffin. It's an opportunity to really maybe save their business when they need it, if they plan early enough. So my feedback would be that as a business owner, if your business is struggling right now, to plan and plan early and have that conversation. I'd rather have a conversation with someone like Alan today than in 3 months when you would really need that conversation. So that would be my feedback.
Alan, I wanted to ask you even for maybe a call to action to someone out there today. Maybe it's an attorney who doesn't handle bankruptcy related issues and thinking about one of their clients, an accountant for sure, who's starting to see some of the numbers and the problems that are immediately happening and or on the immediate horizon, that even something as short as a week might make a difference. You know, the difference between contacting you on Monday morning versus waiting till the next Monday could make a big difference. Can you give us maybe an example or some color to that? Why is it that people should act now to talk to a bankruptcy attorney?
You know, the prime example would be as if there is a foreclosure sale. Once the foreclosure sale happens, there's nothing I can do about it. Before the foreclosure sale happens, I can. Same thing, before a lease is terminated, I may be able to help them. Once the lease is terminated, my ability becomes a lot more limited. So those are two very easy examples of that. And so to the professionals out there, please give me a call. I don't charge just to talk about those type of issues. I want to make sure that you're giving the proper advice to your clients. I want to make sure that that your clients are going to be well taken care of and that they survive.
Thank you so much. So for those of you who are a business owner who wants to talk to Alan, we've got his contact information scrolling on the screen here. Reach out with an email or give him a call. And of course, to those professionals as well, if you're a CPA that deals with a lot of business owners, maybe on the audit side or the tax side for business owners, or you are a transactional attorney or a litigation related attorney, and you don't have the expertise in the bankruptcy area, of course, please reach out to Alan. You could build a mutually beneficial referral relationship, of course. And then back to the Trusted Professional Advisors group that Alan hosts and organizes. For those of you who are in those three categories or other financial categories like bankers or alternative asset lenders who might be interested in joining that, again, reach out to Alan by email and see if you might be a good candidate to participate in one of those Trusted Professional Advisor forums that we host on the last Wednesday of every month. I'll leave the last word to you, Jess, as we're wrapping up here. Your final thoughts and preview to our next DVR in a couple of weeks.
I just want to appreciate everything that everyone's done. I want to appreciate all the likes and shares we've gotten. Dave, I want to say hello to you again. And by all means, please feel free to leave a question. We'll have another EVR in 2 weeks. I look forward to doing that, and I look forward to having a lot of people there and hopefully a ton of questions.
Thank you so much. I'm Jeff Tockman, the Referral Navigator. I work on business development strategy related to referrals. And on the screen that you're about to see, you can reach out to any of us, Jess Coburn, Alan Crane, or yours truly, Jeff Tockman. Thanks for joining us, and we'll see you next time.